Hello everyone, this is Crypto BitLaw, back with your blockchain legal brief, and today we're going to discuss a lawsuit that was recently filed on behalf of a popular esports club against an NFT provider over the failure to deliver the NFTs that were the subject of this litigation. But before we dive in, if you enjoy this content, please hit that like button and subscribe to our channel. We'd really appreciate that. And with that said, let's jump right on in. Okay, so as we can see here, Decrypt reports that G2 Esports files a lawsuit against Bondly over scrapped NFTs on Polygon. Before its recent Solana NFT push, G2 signed with Bondly in 2021 for Polygon NFTs that never materialized. So the skinny on this story is that esports club G2 Esports has filed a lawsuit against NFT provider Bondly per a report. The firms announced a partnership in 2021, and G2 alleges that Bondly misled the club about its NFT production capabilities and did not meet its deadlines. They say, when popular competitive gaming club G2 Esports announced its plans to launch Solana-based NFTs in January, there was a curious question mark hanging over the news. What happened to G2's NFT deal with Bondly, which was announced in June of 2021? Now we know. G2 Esports filed suit against Bondly in Los Angeles County Superior Court on March 16th, according to a report from the Washington Post. Per the report, the filing alleges that Bondly leadership misled G2 about its ability to create NFT collectibles via the partnership and failed to deliver on set deadlines. The Esports team alleges $5.25 million in total damages resulting from the deal, which was a 2-year exclusive agreement signed on June 2nd of 2021. According to contracts filed with the court, per the report, Bondly was supposed to pay a $2 million annual licensing fee to G2 Esports, as well as a guaranteed advance of $1.25 million. G2 writes in the filing that when it sent an invoice for Bondly's first rights payment, the crypto firm responded claiming that it was, quote, past the point of being able to successfully deliver an NFT program. Bondly wanted to pause the partnership, according to the Post report, but G2 refused. Bondly then sought to terminate the partnership, claiming G2's unwillingness to find a solution. Quote, Bondly and its agents knew that their representations were false when they made them, or made the representations recklessly and without regard to their truth, reads the filing. They knew they could not perform, but cunningly waited until G2 had publicly announced its partnership with Bondly to its millions of fans to reap the benefits of publicity through the highly valuable G2 brand. Decrypt reached out to both G2 Esports and Bondly for comment, but did not hear back by the time of publication. We will update the story if we hear back from either party. Decrypt previously asked a G2 Esports representative about the state of the Bondly deal in January, but did not receive further information. Bondly, a firm that specializes in NFT collectibles and fan engagement tokens, planned to launch officially licensed NFTs based on G2 Esports and its teams and competitors on Polygon, a sidechain scaling solution for Ethereum, also known as a Layer 2. The G2 Esports NFTs were originally announced to launch on June 30th of 2021, but never materialized. As previously mentioned, G2 Esports ultimately launched a separate new NFT collection in January. The Solana-based collection was created in partnership with Metaplex and treated the NFT profile pictures like a membership pass to an exclusive club for fans of the team. The 6,262 G2 Samurai Army NFTs were released in February. Though they initially sold for 1 Sol, roughly about $90, they currently start at just about 0.25 Sol, or $23, on the Magic Eden secondary marketplace, which shows a total of about 1,416 Sol of total trading volume to date, roughly about $131,000 worth at today's Sol price. G2 Esports is one of many teams to get involved in the blockchain and cryptocurrency industry, particularly over the last year. Other notable deals include FTX's $210 million naming rights deal with Team SoloMid, Coinbase's sponsorships of teams like Evil Geniuses and Team Liquid, and recent Tezos deals with Team Vitality and Misfits Gaming. Okay, so turning to the original Washington Post article, I think that there are a few interesting points here. One of them is that the arrangement in the contract states that the esports brand granted Bondly access to its intellectual property. images, video, and audio relating to the company and its esports teams, and plan to promote the company as an official partner of G2 Esports. So it was a brand licensing deal in a sense. And then here at the bottom, this is also interesting. We could see that there was a quoted tweet rather from Carlos Rodriguez, the founder and CEO of G2, on June 3rd of 2021, that stated, quote, "It's easy to hate on NFTs due to previous catastrophic cash grab attempts from weasels." And when the company's partnership with Bondly was first announced, he also stated that, quote, "We are doing this for the right reasons and will be around for decades to come." But it's interesting when you actually go to find this tweet over here, we could see that it doesn't exist anymore. So I guess someone had a little bit of buyer's remorse on that tweet. Okay, so turning to the analysis of this, I think that there's a few interesting points to note here and discuss. I guess first and foremost is that this action was filed in state court. The articles state that it was filed in LA Superior Court. So we know that it's based in state court rather than federal court. Traditionally, when you file in federal court, you're filing there either because you have diversity, parties from different states and jurisdictions, and the value in controversy is over $75,000. But more importantly, and more likely, the reason people seek out relief in federal court is that the cause of action is based on what's known as federal question. And a federal question is a legal issue that sounds in federal law. So something like bankruptcy, which would be federal law, or intellectual property, in other words, copyright or trademark. Those are all federal law. So if you have a federal question issue, then you would file in federal court, and that would be the proper venue to seek redress or to redress your grievances and seek relief against a party in federal court for those issues. So based off of that, the fact that they filed in state court, I would imagine, even though I don't have a copy of the complaint in front of me, because I suppose it's behind a paywall in the California state system, their dockets are traditionally paywalled, I would imagine that the plaintiffs in this case, G2, they're not asserting any sort of trademark infringement, because if they did, they would more likely than not have to go to federal court for that. I'm assuming it's going to be some sort of violation of contract. So you have a breach of contract action or one of these California unfair business practice statutes. So that's the first point. And next point of issue is that if Bondly did not make the initial payments for the rights of the licensing that they were seeking from G2, then it's likely that Bondly, I could foresee them being either bankrupt or insolvent, or just, in a general position where they're defaulting on their debts. And if that's the case, then G2, they're going to have a long road ahead of them trying to recover in this case, because a debtor that has defaulted or they are insolvent, they're what is colloquially known in the industry as judgment proof. And that means that even if you as a plaintiff get a judgment against a defendant who is judgment proof, if you get a judgment against them for cash damages, monetary damages, it is unlikely that you will be able to recover due to that defendant's insolvency. And so that's another interesting point of note. It's also worthwhile to consider that G2 was Bondly leveraged the G2 brand in an effort to pretty much pump their own brand, as was noted in one of these articles, that G2's alleging that Bondly pretty much used G2 to get the notoriety of the G2 brand in order to announce this partnership and then gain some sort of either notoriety or fame or exposure based on the fact that there was this partnership. And I could definitely foresee that being probable. However, at the same point in time, it's also worthwhile to consider that it's possible, based on the present trading volume of the NFTs that G2 ultimately released on Solana, the fact that the present trading volume is only around $131,000, that it's possible Bondly knew that this project really wasn't going anywhere in terms of the monetary value. if they engaged in annual licensings, Bondly did with G2 for about $1.25 million in the licensing deal, and it's only trading at $131,000, then there's not much meat on the bone in terms of profit. So that's another point of consideration. But with all that said, I think that this is an interesting situation. Certainly, we're going to see more and more of these types of actions and this style of litigation arise as different prominent brands seek to team up with NFT companies or various blockchain digital asset companies to release some sort of product or engage in a partnership on the blockchain, and then ultimately their relationships run sour. So this is just the beginning in a wave, an incoming trend of this type of litigation. But with that said, I hope you guys enjoyed this content. We enjoy producing it for you. And if you did, please hit that like button and subscribe to our channel. It would really help us out as we seek to grow and continuing to produce more and more fresh, new, innovative content for you all. And so with that said, thanks again for watching, and we will see you all in the next video.